final disclosure item 1, LPA 483 of 1924.
No, sir. I have a request. I have to pray. The copies were served on us on Tuesday. Attempt was made to serve it on Monday evening. My friend had left court by 3:45, so it could not be served. From the pleadings, we were under the impression nothing new ground, nothing new has been placed. But it appears they have taken few new grounds. That need to be looked into because we need to look into it.
You look into that.
So that means for that we need time because I could not prepare. It's not possible.
You have filed one IE also.
I know your lordship said that we have sought leave. It's up to your lordship to look into it, not to look into it.
No, it can't be like this.
I am not.
Once you file an IA,
yes, his lordship.
some order has to be passed on that.
That's what I'm saying. I am not.
And this office, why have you not placed the IA? परसों फाइल हुआ है. It was not reflecting in the computer. नहीं, आपको 2 दिन पहले नहीं फाइल मिला. आप कितने भी समय फाइल प्रिपेयर करिए, लेकिन लास्ट मोमेंट का फाइलिंग हमारे पास रिकॉर्ड पे आना चाहिए. Because of this, I do not know what is the IA about, but I can guess what is it all about. I will pass a judicial order that you have to check till 5 o'clock of the last evening when the matter is sent to us for reading the brief. You have to check till 5 o'clock. क्या फाइल हुआ है, क्या नहीं फाइल हुआ है. Rejoinder, supplementary affidavit तो ऑफिस लेगा नहीं. 48 hours का नोटिस रिक्वायर्ड. IA ले लेता है, सेम डे भी IA ले लेता है. तो इट इज़ योर ड्यूटी जाने के पहले चेक करना और उसको हमारे पास भिजवाना, और छूट जाए तो किसी के हाथ से भिजवा देना. ठीक है, ये चीज़ दिस इज़ नॉट एक्सेप्टेबल टू अस. हम लोग आधा फाइल पढ़ के कोई केस डिसाइड नहीं कर सकते. विल पास एन एडवोकेट ऑर्डर. कुछ ऐसा बात नहीं है, ये कोई नई बात नहीं है. वी विल इंस्ट्रक्ट द ऑफिस टू डू द नीडफुल फॉर दिस कोर्ट. This is the IA.
This is the representation.
In fact, your lordship was observing.
The representation was so voluminous, therefore not annexed. The point was that. In fact, what we have said in paragraph 3 of my application is that the pleading was there in paragraph 12 and 18 of my writ petition, which was acknowledged by them in paragraph 9 of the counter affidavit. And the reference to this document has been mentioned in annexes 5 and 10.
We are concerned with it because of this, that the learned single judge has observed that because of non-disposal of this
Yes.
representation, you have been prejudiced. So we want to know that a representation which is not based on record, how a finding of prejudice could happen. Secondly, in your subsequent representation, you had stated that you had already filed a representation giving all the details and you wanted more documents to respond.
Yes.
So we do not know, because you are already in possession of all the documents. We do not know. CBI has seized, but prior to that you have filed your representation. It is prior to seizure by CSC.
That I am satisfied. On all these points, we are satisfied.
But it is something which is absolutely new you are bringing on record. So
Because
let them with all, there is no explanation for not filing this representation.
Correct.
Even without the annexures you could have filed. We do not know whether you could have filed or a truncated document or not.
I know.
But this IA has to be dealt with, and so they will have to respond to it. Otherwise also you are praying for time.
Because I am not just praying for time.
Therefore, considering the nature of direction issued by the learned single judge, there has to be a stay.
No, it's coming on 23rd of October, the contempt.
No, we are not concerned with that.
It's coming
Whenever
on,
it is coming, we are not concerned with that.
the
You
point
see,
is-
they are not supposed to wait for the contempt petition to be filed and taken up, right? There is a direction. How much time do you need to respond to that?
Not only that, but can I just indicate one thing? There are two things. Once the disciplinary proceeding was initiated, there was an interim order by the single judge. The disciplinary proceeding did not. During the operation of the stay order, they were compulsory retirement. That also was stayed by the single judge.
There is no stay to that effect.
Yes, it's not.
Show me that stay order.
Yes, I'll just show.
Yes, that was.
That was state, my lord. That was state.
आप जब देखिए कौन सा ऑर्डर सर
हाँ, एक-
बताइए
Yes, Lord.
which is that order of state
Yes.
that no coercive steps will be
No,
taken
no, not only no question, there was
or
order to be kept in abeyance. The order of compulsory retirement was order to be kept in abeyance.
where is that
In December 23, my lord, there's an order. Next second.
19 December 23. 19 December 23.
what is the order of compulsory retirement
5th of December.
5th of December
It was communicated to them on 12th of December, my lord. And because on 5th of December it was said it will be effective from the date when it is being served upon him. A lot
so
of
it has
efforts
already
were-
taken its effect
Okay.
by the time the interim order was passed
Yes,
Right from was an interim order saying keeping it in abeyance. my lords. The order was kept in
you
abeyance.
see now whatever be the
I am
order
not on that. Lords. That was never, the interim order was never complied with. I was not taken back in service. Let us be very clear. I was not, we filed a contempt, we filed an application, the learned single judge says we'll hear your matter finally, they filed an application for recall that. All I am saying is that today I was on K. I have been served day before yesterday, or let me take it on Monday. I'm just seeking and I'm just showing you.
I will give you time
So the stay, my lords, and therefore there is no pressing need for an stay of the order because the order, if it all stayed, that order was also not complied with. So my only request is, your lordship may have it before 23rd
you
of
see you
October.
remember on Friday when this matter was taken up it was made very very clear to both of you that we will finally hear the matter and
Correct.
decide it because I could see the urgency in the matter on part of both the sides because you also wanted this order to
that
be
is the reason
complied
your lordship have fixed today.
I completely
and
understand.
now by virtue of whatever reasons that you say that new grounds have been
I can
taken,
show it to you, lordships. I can show it from page 26, 92. Page 26,
then
ground number
you
M.
will be filing your reply also to this
Because this ground, I have a
page
simple.
26
Kindly see, page 26, ground number M.
yes
For that, the railway board circular number so and so dated so and so was brought to the notice of the honorable court. But most important aspect of in the case of the petitioner, which actually led to his premature retirement consequent to the review officer, could not be brought to the notice of the honorable court, which is produced below. Para 4D I integrity 1 action or decisions taken by the employee which do not appear to be above board complaints received against him for suspicious property transactions for which there may not be sufficient evidence. So they admit it could not, it is the most important thing and could not be produced. If it has not been produced and it is the most important thing, then how does the order of the learned single judge become bad? They must go file a review. We'll take on.
so you also go and file a review
Now, I have nothing to, why should,
because of non-disposal of this representation.
because that will not make any difference to so far as my premature retirement is concerned. Now kindly come to Q.
You have brought on record these material.
No, that material is
So
still
far as
not.
part is concerned, my lord, so far as the circular is concerned, that was not there. my lord. But the principle which is there, my lord, that has been argued. So far as the compulsory retirement principle is there, my lord, that has been argued.
So the principle
No,
of compulsory
that is a
retirement-
ground that is one of the ground which has been mentioned, my lord. It is not as such, my lord, so far as the factual part is concerned, that is to be addressed to your lordship, my lord. If, my lord, the circular or the rule is there, my lord, that is to be examined by way of law, my lord. This is not a factual part which is to be ascertained, my lord. This is not a factual part. Fact, my lord, so far as that part is concerned, there the law is to be applied. Therefore, so far as that part is concerned, that
How
is
much
to be.
time do you need and how much time do you need
No,
to reply to this item?
I will not-
I need only sufficient time, not let it come immediately in the reopening first week, I'll be ready with the matter. Before, I am saying, before 23rd, your lordship may have it, I just need to be ready on the matter, it's my inability also, your lordship will say.
By that time, we will also file, my lord. There is no difficulty if at all, my lord, the matter is being adjourned.
It is they are seeking adjournment.
No, my
You
lord,
can't do it.
therefore, my lord, I am submitting, my lord, so far
Yeah,
as, but my
that's-
lord, I will pray, my lord, so far as by that time, my lord, the imperial order may be stayed, my lord. While we have filed a stay application, so far as that part is concerned.
We'll take a call on that.
It was filed within time itself.
Now, I have unnecessarily, the caveat was served on them on 19th of August. They should have promptly served a copy on us. It is not that we have delayed. That's the purpose of filing a caveat. That if we have had interim relief, a prayer for interim relief, I must be heard. Anyways, they are not complying the orders, and there will be no coercive orders by any court to comply. So I am also saying that once the matter is before a division bench, I know it matter is ready for hearing, but I will also not press the contempt.
Then I'll say that you are not insisting on compliance of this order. As
Your
of
Lordship-
now,
As of now, Your Lordship, I will not press the contempt. That's all. My words are this. I will not press the contempt. I will not.
And
Because
therefore they
what's
need-
the point in what? I will not get any fun in pressing the contempt, and they will come and immediately get a stay. There's no. I won't do that. Your Lordship may record that I will not press the contempt is listed for 23rd. I'm ready for hearing before 23rd, and in any event, I will not press the contempt. I'm saying so.
that will serve your purpose.
Yes, why not?
Definitely.
When do you want?
I was
It
only
has to be on a
requesting
Friday
Friday.
because now it is a tied up matter.
Friday, no? October. No, so the first Friday is 18th after reopening. Or 25th. It was 25th. Your Lordship.
Choose your date.
I can pray for 25th. No, sir.
25th of October.
October, yes. I'll keep it.
Will you respond to the IA?
This one we will file formally. Because so far as that representation is concerned, that was with respect to the sanction application which was to be objected, but that is the heading with respect to the representation. Therefore, so far as the right of hearing on the
One thing which will certainly come up for consideration is whether by issuance of a charge sheet to a person initiating a departmental proceeding, and you say that a parallelly criminal proceeding has also been initiated, and therefore the departmental proceeding has to be stayed. That was one of
Yes,
the
one of the.
grounds.
Yes, ma'am.
Is there any legal bar in exercising a power of compulsory retirement?
When a criminal proceedings. Yes.
no.
Right? When the criminal proceeding is there, charge sheet has been issued to you, and is there any legal bar in doing that?
I will answer. I have an
And
answer.
secondly, as I find from the counter affidavit which was filed by Union of India, the material for considering the compulsory
Compulsory.
retirement was also not placed on.
It was.
It was not there.
But counter shows here and there what were the reasons. I can. That
Yes,
is recorded.
but that is not sufficient because counter affidavit will not actually be the reason. The reason has to come from the files.
That was not produced.
That was not produced by them justifying it. Now they are trying to justify it. Have you
No,
brought
they
it
have
on
still not
record?
brought on record.
That had not been brought.
You can bring it under seal
I'll-
cover.
I'll
I have no difficulty. Let them produce it before election.
Okay, you can also have a look.
Yes, yes. But that is my records only. It is not a confidential record so far as it is not for the world. It is for us only to assist your lordships.
That's
we will bring it on.
you bring it on record
Yes.
in sealed cover. The procedure regarding order of
Compulsory
this
return.
compulsory return.
Yes, kindly. Because from the affidavit, what we could gather is that they had taken a decision within a period of 5 days. It usually review starts according to them also from the quarter. So October it should have started. We said the first of December it started at 5th January. So those things were evident from the affidavit.
So ultimately, if the reasons come on board, it will be easy for us to act.
100%. Your lordship may kindly, because we will also be more comfortable in placing our case that there are no reasons, and then your lordship can test the judicial review the reasons.
IA number 10552 of 2024 in LPA number 483 of 2024. The learned counsel for the parties are present. This interlocutory application has been filed to bring on record the representation dated 14/1/2022, which, according to the writ petitioner, was never disposed of, and non-disposal of the same had caused prejudice to the writ petitioner. It has been submitted by the learned counsel for the petitioner who has filed, writ petitioner who has filed this interlocutory application, that since it was not on record but it was mentioned in the writ petition, the same is sought to be brought on record through this interlocutory application. The learned counsel, the learned ASGI appearing for the appellant, prays for time to respond to this interlocutory application. At this, the learned counsel for the appellant has submitted that since there is an order to take back the writ petitioner with immediate effect, he has also filed a petition seeking stay of the impugned judgment passed by the learned single judge. Therefore, the operation, implementation, and the execution of the impugned judgment be stayed. To this, the learned counsel for the writ petitioner has submitted that the contempt petition is posted on 23rd of October 2024 before the learned single judge, and he undertakes not to press the contempt application. He has submitted that instead of passing an order of stay, he is undertaking revision.
Yes, yes. And copy of the IA also seems to have been not served on. But Your Lordship will not take it on record. I'll request my friend to stake IA.
Then
Miss ho gaya. No,
It has
Your Lordship will
also-
not record all this.
it has also transpired during the court proceedings that it has also transpired during the court proceedings that the concerned connected record of decision to compulsorily retire the writ petitioner was also not brought on record by the Union of India in the writ petition, in the counter affidavit. However, they have justified, they have tried to justify the same by making statements in the counter affidavit. Considering the nature of dispute involved in the present case, this court finds it proper to summon the files concerning the files containing the entire proceeding which has been undertaken by the appellant in order to compulsorily retire the writ petitioner. Let the file be produced before this court in sealed cover. With the consent of the parties, the matter is adjourned and is directed to be posted on
25th.
25th of October 2020. The reply to the interlocutory application should be filed by 15th of October, rejoinder, if any, by 24th. The connected record in connection with the decision of compulsory retirement of the writ petitioner be handed over to the learned court master on 24th of October.
Before that.
एक दिन
उसके
on or
पहले-
before 24th of October.
Yes, ma'am. Before that.
Since the learned counsel for the writ petitioner has undertaken
Yes.
not to press the contempt petition, there is no requirement to pass any order on the stay petition as of now.
ma'am.
Post on 25th
25th.
at 10:30.
Whatever time suits. Yes, sir.
10:30.
If Your Lordship had ordered last time, the permission of the chief is required or not, I don't know. It's here because
Now, not the
because the
case
division
is
Now-
already there. Now
It
the
is
order-
assigned to this bench, I think.
the
whatever
case has already been assigned to your lordship
हाँ,
bench.
it is an assigned matter. Assignment है ना?
yes, it's
This is
especially
after
assigned.
assignment only on the last date.
That's right.
Matter was shown.
In case you don't want to argue on 25th, give advance notice. उस दिन हम adjourn नहीं करेंगे.
नहीं, हम भी तो नहीं चाहेंगे पर whatever it is we also
And yesterday, the matter which has concluded, we were asked to
Share.
give the soft copy of the orders.
I know that we are
Word
working on it.
document.
Because we are working on it. It has to be typed.
Yes, it has to be typed.
The soft copy of the my impression that we have to type it and
No,
give it.
no, no.
Actually, only the
What you have to do is,
just scan
it's a
and give it.
PDF.
Oh,
You scan, you
Mr.
convert it into. You don't know.
That we know that. A Word file will give it, but it's convert and give it.
Convert and give it.
No, because one of the orders may not
Is-
convert
yes.
into OCR.
Yes.
So that
But
that's
that can be done substantially.
it will be done.
तुरंत हो जाएगा.
हो जाए कल
करके दिखाएं.
नहीं बट हम जानते हैं आपको नहीं सर